Appearing before a 5-judge constitution bench led by Justice Abdul Nazir, citizens challenging the Union government's 2016 demonetisation policy faced a unique challenge today. The court had not heard the case between 2016 and 2022. Meanwhile, the Union's plan to replace all 500 and 1000 rupee currency notes is irreversibly complete, a fait accompli, as Justice B.V. Nagratna called it today. Senior advocates Shyam Devan and P. Chidambaram, appearing for the petitioners, had to prove to the bench that the case still posed legal questions worth their time. Despite the bench's initial reservations and the Union government's best efforts to have the case declared infructuous, the lawyers succeeded in convincing the 5 judges that they must decide if the Union has the power to declare all notes of a currency illegal. At the end of the hearing, the bench directed the Union to come back with details and documents of the Reserve Bank of India's meeting, where they discussed the policy before its announcement. Meanwhile, in the Chief Justice's court, the bench issued a final order in a case seeking implementation of the Supreme Court's 2015 judgment in Shreya Singhal v. Union of India. In this case, the Supreme Court had declared that Section 66A was unconstitutionally vague. Section 66A of the Information Technology Act 2000 prescribed punishment for sharing grossly offensive or menacing information online. In 2015, the court said that the provision did not qualify as a reasonable restriction that can be imposed on the freedom of speech and expression. It declared the provision to be void ab initio, meaning it should be treated as though it never existed. In 2019, the NGO, People's Union for Civil Liberties, approached the Supreme Court seeking directions for the implementation of the judgment. The court directed that copies of the judgment should be made available to the chief secretaries of all states, who in turn would educate the police about the development. However, the provisional was still used to arrest citizens for their offensive speech online. So, PUCL approached the court again for more directions to ensure that Section 66A is not used to make unconstitutional arrests. Today, the Supreme Court issued 4 directions for the implementation of Shreya Singhal. First, no citizen can be prosecuted for an alleged violation of 66A. Second, all cases in which citizens are facing prosecution under 66A will be deleted. If a person is charged with multiple offences, including 66A, only the charges under this provision will be deleted. Third, the court directed Home Secretaries, Director Generals of Police, and other relevant state authorities to ensure that the police no longer use Section 66A. Fourth, in all government, semi-government or private publications on the IT Act and Section 66A, readers must be adequately informed that the provision has been struck down. Thank you for watching SCO Daily. Visit our website and subscribe to daily morning updates on WhatsApp or Telegram.